So this video is all about what's required for the sworn detailed descriptive list of assets and debts after somebody dies, what that's all about. But before I get into that, I want to tell you one quick little funny story. We finished up with an estate planning program for a married couple, and on the drive home, the husband turned to his wife. He said, dear, if I pass away, I want you to be happy. So if you marry someone, feel free just to use our home, live in our home, and use all of our money and enjoy yourself. I want you to be happy. And you know what? If your new husband wants to use my fishing equipment and all my tools and drive my nice vehicle that I have, I don't have any problem with that. I want you to be happy. But then he went on to say, you know what, there's one thing that would really bother me. I really wouldn't want your next husband to use my golf clubs. That would really bother me. I'd roll over in my grave. So just sell my golf clubs after I pass away, sell them in a garage sale. And his wife turned and looked at him and said, no worries, honey, he's left-handed. So there you have it. Anyway, back to the sworn descriptive list. In virtually every succession in Louisiana, when somebody dies, the family hires lawyers like myself, and the lawyer's office has to prepare, among other things, what's called a sworn detailed descriptive list of assets and liabilities. It's a picture of everything that the person owned when he died. So if they owned any separate property, like maybe they inherited or were given assets to them, or maybe they brought assets into the marriage, those separate property assets will be listed. If they own community property with a spouse, all those community property assets would be listed. All of the values of the assets are listed. So if you see a community property asset, maybe a home was worth $300,000, you'll see the decedent's 1/2 community property interest listed at $150,000. So all those assets and their values are listed. What assets typically get listed on there? Well, all the real estate, the legal descriptions, the bank accounts, the account numbers, how the accounts are titled, the bank balances as of the date of death, the investments, the stocks, the bonds, the mutual funds, the vehicles. Now, unless there's an estate tax return that's required to be filed, but that's only for people who die with more than 11.2 million, no real formal appraisals are necessary. So people want to get the values right, but with real estate, we typically have them just give us their best guess of what they think that might be worth, because nobody's going to double check that unless perhaps it's a contested and litigious succession where you've got to get everything perfect, because everybody's going to question everything. But and know that with cars we use blue book values. Pretty easy to determine the bank account balances and the investment on publicly traded investments values. But the real estate, you can take your best shot. Now it is important though, because the value on the date of death establishes a new capital gains tax basis for the heirs. So when the heirs turn around and sell that asset, they'll pay tax on the appreciation since the date of death. So getting that valuation stuff can be important for capital gains tax purposes, not as important for estate tax purposes. So all the debts get listed. If the person had any mortgages or car loans or credit card debt or other debt, that gets listed, who's owed and all the account numbers and all that. All the administrative expenses, from court costs to attorney's fees, to other debts that might exist. So that detailed descriptive list really is the centerpiece of the succession, because quite frankly what happens is all of that information from the detailed descriptive list gets kind of copied and pasted into the formal judgment of possession that the judge signs, ordering that assets be transferred to the heirs. Those documents are similar in content, but the judgment typically doesn't list the values of the assets. It just lists the assets, whereas the detailed descriptive list lists all of the personal, financial information. Now, an important note there, just last year in 2017, they changed the law, because there's always been a concern that, what if dad dies and mom and dad were very private in their finances, and so after dad died, now mom's got to give all the information to the lawyer. The lawyer's got to prepare all the detailed listing of all the accounts, the investments, the net worth. That gets filed in the succession record. All that's at the courthouse. It's in the public record, and in many cases it can be on the internet. So they just passed a law months ago that said that the detailed descriptive list of assets, all those account numbers and account balances as of the date of death, it can be a sealed document in the succession record. So I know there's a lot of predators out there that can search the probate records, find out who those surviving spouses are that have significant wealth, and then go attempt to prey on them. Terrible, but it happens. So now there may be some protection for that because that detailed descriptive list can be sealed. So there you have it. Just be aware that there's a lot of information to gather when somebody dies. And if you want to know more about that, check our videos, subscribe to our YouTube channel. If a family member passed away and you want to start that process rolling of getting the estate settled, you can contact our office, 866-491-3884, and we'll be glad to have a discussion with you about what that might look like and a plan for getting everything done. Hope that helps. Hope you liked my joke at the beginning. If you did, you probably need to comment maybe with another joke that I could use on another video. So estate planning, kind of dry, try to liven it up a little bit. Have a great day.